The media has done a very bad job about explaining the September 18th trial date for Judge Merchan to allegedly sentence Donald Trump. Um, on August the 16th, Alvin Bragg and Juan Merchan sent a letter, I should say Alvin Bragg and Michael Colangelo sent a letter to Judge Merchan asking, or basically saying to the judge that it was up to him whether or not there would be a stay of the September 18th sentencing date. That letter was reported in the press, and basically the import of the letter was it was up to Judge Merchan. As of this filming date, Merchan has not acted on the letter, but I think as I posted on my Twitter account or my X account, it's my pinned post at my account at Donald Russo 994. I attached a copy of the Bragg Colangelo letter of August 16th, and I said, built into that letter are several points that cannot be denied by Merchan. Now, granted, it is up to him to make the decision. However, as noted by Bragg and Colangelo, in Trump's letter of August 14th that he wrote to Judge Merchan, he was discussing the court's consideration of his post-trial motion, which they call the New York CPL 330.30 motion, post-trial motion. And now, according to Bragg and Colangelo, in their letter of August 16th, they said that for the first time, Trump's lawyers raised the issue of an interlocutory appeal. That means an appeal prior to the final resolution of the case. Now, they in the prosecution's letter of August 16th, they concede the fact that since Trump raised an immunity issue, he does have a right to seek interlocutory review of that. Now, here's where the problem comes in. Judge Merchan gave himself until September 16th to decide the post-trial motion, and then he scheduled a sentencing date for September 18th. Now, as indicated in the letter from the prosecution, let's say that the post-trial motion is denied on September 16th. That means that from September 16th to September 18th, Trump has got to file his request for an appeal, interlocutory appeal. They indicate in the August 16th letter that basically the appellate court is going to have to grant that motion. They're not going to have any choice because you can't request somebody who has a right to file an interlocutory appeal request to do all the briefing and everything necessary to complete the appeal within 24 hours. Basically, if the post-trial motion is denied on September 16th, that means on September 17th he'd have to file a motion. What would the court do? What would the appellate court do? They have to grant an immediate stay. They have to. Another point raised by the prosecution, to their credit, in the letter of August 16th, is that you can't ask all of these agencies to provide all that security for what's going to be a mad rush of publicity over this alleged scheduling of Trump. So what if all these agencies fall into place, expend humongous resources to pay for all the security necessary, and then, boom, before the September 18th sentencing, the appellate court stays everything. So they're saying, I think the prosecution is pretty much saying, decide it now. Decide the issue of whether or not you're going to grant the extension now. I doubt that Judge Merchan is going to let this thing drift up to his final day of September 16th. He has every right, Merchan has every right to decide the motion now. He hasn't. Now, another issue I raised in my X post is that if you look at the August 16th letter from Bragg and Merchan, they're saying in that letter that Trump is not asking for immunity for himself. He's objecting to some of the evidence that was submitted during his trial. They call it an inconsequential amount of evidence, or they call it a direct quote, a sliver of evidence. Now, I don't think it's the prosecution's right to unilaterally characterize how much evidence is necessary to constitute a federal issue. This whole thing obviously was caused by the July 1st, 2024 Supreme Court immunity decision. You may recall, and I did post about this back in March, I think it was about early to mid-March, the Department of Justice, Federal Department of Justice, dumped on Bragg about 2,000 pages of federal material. Trump at the time requested an extension of his April 15th date. I think it was about a month, about March 15th, and this is in the public records. You'll see news accounts about this. The DOJ dumped about 2,000 documents on Bragg. And Trump's point was that how can I go through all these documents and be, ready for the April 15th trial? Those documents, I'm assuming, included, you may recall that Robert Mueller, special prosecutor for the Trump-Russia collusion, he did a search warrant against Michael Cohen's office, and he came up with all the material about the Stormy Daniels, the $130,000 payoff, the so-called hush money. That information about the Stormy Daniels payments came because the feds raided Michael Cohen's office. Michael Cohen was charged, and again, I haven't seen this evidence, but I would assume that if Bragg is bringing charges based on information he got from Robert Mueller in the first place, then how could he say that there's an inconsequential, a sliver of information? Where did all the information about the payments come from? It came from that Robert Mueller investigation. I mean, there were issues there, whether or not they had the right to go into Michael Cohen's office under the attorney-client privilege. They blew right through that, and they raided Cohen's office under, notwithstanding the attorney-client privilege. But my argument is that we don't know how much federal evidence there was in the Trump case. I have to assume that, as I said, that the provenance of that information came from the Stormy Daniels information that was gleaned by Robert Mueller as a result of that raid. So now this becomes even more complicated because Merchan has to, in my view, Merchan has to have an evidentiary hearing. If you're going to have the prosecution say, "Oh, it's only a little amount of federal information, it's an inconsequential amount," he's going to have to have an evidentiary fact-finding hearing. I would assume, and I would argue, that every one of those documents has to be reviewed in open court, and a record has to be made before Merchan can make a decision on that post-trial motion. You can't just go by an offhand comment by the prosecution that there is only a sliver of information. And as of this taping, I am not aware that Merchan has made any attempt to set up any kind of hearing, a fact-finding hearing or evidentiary hearing. So either Merchan has to decide on the post-trial motion now and give everybody a couple of weeks prior to September 18th to decide what they're going to do, give Trump some time to file his request for an appeal. But the bottom line is this. It sort of annoys me that everybody's saying, "Oh, there's going to be a sentencing of President Trump on September 18th by Judge Juan Merchan on the so-called hush money case." I just don't see how that can happen. Granted, theoretically, it can happen. Merchan can do whatever he wants. He can decide the post-trial motion now. He can decide it on September 16th. Now, he did, as I said, give himself until September 16th. Why he gave a 2-day window between the sentencing date of September 18th and the final date for resolution of post-trial motion on September 16th makes zero sense. So I think, as I noted in my pinned post on my X account, Judge Merchan is painted into a corner. He's painted into a corner with this. He has to grant the extension of the whole case. He either has to decide the motion and give Trump a right to file his appeal now, or he just has to say this whole case is delayed until there's a further resolution on the appellate level, because Trump does have some appeals pending. So I really, given the volatility of this election and the fact that the election's barely 70 days away, to go around saying that Trump is going to be sentenced on September 18th without reading through this record is close to being cavalier and frivolous and not careful at all. Another issue, and I wrote a Substack piece about this, On May 29th, there was what appears to have been a jury tamper. The guy, I think the name was Michael Anderson, May 29th, he put something on his Facebook post about his relative, his cousin or something, who was on the jury, and that they were going to convict Trump the next day. Now, Merchan immediately sent out a letter to counsel, and this was in the press, and we have heard no resolution, no resolution about this at all. Was there a fact-finding hearing? I'm not aware of anything having been scheduled. So you could say that that was an unimportant matter, that the post by this Anderson guy was a no big deal. But if it was a big deal, why did Merchan write the letter and notify counsel? And why hasn't there been any indication of a resolution of did that happen or not? Now, they said, the guy himself, Anderson, said in another posting, he said, this is a, quote, a shit post. He was making fun of his own post. But he did it. He made a certain factual statement about a relative. That's pretty important stuff. I haven't seen anything else written about this. I wrote a Substack piece about it called The Summer of Juan Merchan's Discontent, because I think there's a lot of things swirling out there. But bottom line is, next time you hear somebody talking about Trump's sentencing on September 18th, you have to ask yourself, in light of these factors and in light of what's actually in the Bragg and Colangelo letter of August 16th, I just don't see how there's going to be a sentencing on September 18th. It's not going to happen.